But now with emails, with WhatsApp, it becomes challenging, and how to kind of put everything together.
The client will actually turn back and tell us this does not fall under the definition of change as in the contract, you see. Hope that the client's lawyers agree and let them be the one to advise the client.
The keyword is hope.
Welcome to ArchitectuREAL, where we explore the real lives of architects and get real in the world of architecture. Hi everyone, thanks for tuning in to ArchitectuREAL, Real Architects, Real Talk. Today we have Chin Xiong, Harold and Stephen with us. And the overarching topic today is client versus contractor. Maybe let's dive into a slightly deeper question. For example, all contracts, there's no perfect project, where things are just 100% smooth. So in the event where there are contract delays, right? It could be due to the client's, change requests, or maybe there are protracted confirmation on things, or maybe even the contractor's fault. But your time on the job becomes extremely extended. What are the common causes of this kind of prolongation that, in your experience so far as an architect, you have come across?
I think there are many situations. It's quite common. I think in most projects, where the project is getting protracted for reason of the client side or from the contractor's delay. And I think going back one step is, as you mentioned, clients' protracted decisions, etc., or delay in making decisions. And I think one of the fundamental things about contract administrator is that there's always this sense that between acting as an agent for the client and being a contract administrator, there are conflicting roles. But if you take a step back and it says that, look, the idea here is to be fair, and there is a contract to administer, and client would expect you to look after their interests as an agent in the contract. And to me, that doesn't conflict with ensuring that the client complies according to the contract. Otherwise, it will likely end in disputes, and that's not to the client's advantage, not to the project's advantage. So I think with that in mind, we can just manage the best we can at the start, kind of putting across the client, so that any decisions made by them in the delay and everything, they will recognize that there will be consequences, be it variation, be it extension of time, be it delay or protract. So I think the issue most of us will face is, at the end of the day, client will not blame you for giving an extension to the client, extension of time to the contractor, and he gets angry with it. And so if you kind of manage that portion, then it becomes so-called better.
Because often or not, the client may not fully understand the consequences of what they have changed, especially during construction period. So although they may say it's only a change one design of one component, but there are also a lot of downstream effect. They have to place order early. Some of things, once changed, the lead time becomes even longer. So these are our duty to advise the client what are the implications down the road. So from first hand, they know this decision will impact their contract completion.
I'd like to just maybe chime in with the one very recent example. I think my fellow practitioners here, we're well versed with default forms of contract that are in the system. So in a certain sense, we seem to take the view that, okay, it's supposed to be like that. I think one thing that I've noticed in my current work here is that read the contract very carefully, because, for example, my current contract here states and defines in an entire section schedule what does change mean. So what happened is that, when we were trying to trigger off a few VO claims, on our general understanding, the client would actually turn back and tell us this does not fall under the definition of change as in the contract, you see. So I think in a certain sense, one thing that we need to be a little bit more mindful as an administrator is we better read the contract thoroughly first. Yeah.
I mean, that's one of the things. Over a recent case, we have a client who, wanted us to brief them on every clause in the contract and what it means. Okay, we went through the whole session with the whole panel, and then there was suggestion to change certain clauses, obviously to the advantage of the client. And we took a stand to say, look, you can change, but you cannot empower us to change it. You have to get a legal advice, because I say you change one clause, it may affect another clause. And at the end of the day, we cannot be responsible as a contract administrator to ensure that everything ties up properly. So in the end, they stuck to whatever was in the original SIA condition of the contract.
So that's also another interesting topic point that you brought up, because there are instances where the client wants to change something and they ask me whether it's okay or not. Or let's say the contractor says they want to change something in their contract between them when they're getting awarded. So the client will turn around to ask me to say, do you think this is okay? My opinion is that I think because we are still not lawyers, and there are so many clauses that reference each other. When you change something like what you mentioned, right? Is it watertight?
Yes.
We're not in a position to do that. So for me, what I told the client was that I feel that it's okay, but it's best you get a lawyer to vet through, because it's beyond my expertise.
Correct.
Yeah.
That's exactly what we kind of told the client. It's not to change. If you want to, you better get a lawyer to look into it.
Proper legal advice.
And also, I think one thing just to add in is that to your earlier question is that I think no party within a contract should be allowed to unilaterally alter the terms, especially if it's coming to agreement or post-agreement, at least not without a supplementary agreement that is attached to it. I think many times, as Stephen had always pointed out, the client wants to put a change or something like that. And as an administrator, you know that this change is not so-called supported within the terms of the contract. So the part, and back to the temperament part, and this is where you need to tactfully explain to the client that measures must be taken correctly, or so that the terms can be altered to all parties' agreement again.
Okay, so for other things like I think Cheng Siong had mentioned earlier in terms of informing the clients whenever there are change requests on how long it might take, that basically informs them and let them make a decision whether they want to take up that change or maybe just forego the change. But what about delays from the contractor's side? When there are causes, when there are incidents where it caused a delay in the whole contract, there's no correct me if I'm wrong, I don't think there is a mechanism for you to claim for additional fees from the contractor, because your contractual obligation is between the architect and the client. So in such a scenario, what do you do?
I think in the first place, when we sign the service agreement with the client himself, we will have already factored that in our service fee. You cannot be expecting the contract will run very smoothly to the dot. Definitely, we anticipated some kind of delay, and that's a risk factor on our side for the service fee claim. So we have to factor that already in our service contract.
Well, in the contract, in agreement, architect's agreement with the client, I think under the SIA appointment, there is already a clause to say that you can charge for protracted services. And I think it's a lot to do from a business point of view, play-by-ear situation. If the client has been reasonable in terms of their payment, they've been quite accommodating, we'll just kind of waive that. But so often that if the projects get really protracted too long, and then it will be an issue of negotiating with the client, and to see whether some form of additional fees could be paid to the consultants. Again, I think this is, although it's in the agreement, kind of very hard for us to exercise it.
It's never easy to ask
Yeah,
for
correct.
That is true.
But actually, it depends on your client also. Like, I mean, for us, we have a very corporate client. So what happens is that even the client themselves want to distance themselves, and they go through a legal protection layer, so to speak. So because of that, we can then leverage on the contract to say that, such and such event had delayed, and we have demonstrated where the delay is. And for us, the protocol is to put in a histogram to demonstrate the effort required to service this extra effort down there, and then put in a claim, and then cite whichever the clauses under the service agreement, and then after that, hope that the client's lawyers agree to, and let them be the one to advise the client.
So the key word is hope.
It's spelled ARCHITCET.
Okay, we shall remain hopeful. Okay, so moving on to DLP, defects liability period. So when defects show up, how do you manage when there is a dispute? So in a scenario, what happens, for example, what happens when the contractor turns around to point the finger at the architect, citing reasons such as design flaw or architect's specifications? Because obviously the design is done by us, and sometimes materials, finishes, we would have been the one to spec it. Of course, they can choose whichever supplier they want, but they turn around to point finger, then how would you handle such a situation?
Very tricky. Okay. I think if the defects, first I think whether it's to be proven whether the defects is a result of a design issues, or whether it is really workmanship, or it could also be a situational issues where existing site conditions has caused the defects, unforeseeable, so I think whereby if it's an issue on design, I think first it has to be proven, and I think it also comes back to the architects in the course of preparing your tender documentations, your design specifications. I think efforts has to really be put in to ensure to minimize to mitigate such issues from happening. But once it's happened, then I think realistically you have to sit down and find an alternative solution to solve the problem. Now, whether there'll be costs involved, or whether often you end up having to whether to discuss with the client or even the contractors on who to bear the cost and how to mitigate this issue. And often it can even be done without much cost, depending on how you look at it. So I think it comes back to the role that Harold mentioned, being an architect and being a contract administrator. So your role as an architect, as a designer, you have to be very conscious that you'll be the contract administrator subsequently. So whatever you do up front, you make sure that it's well covered such that it's easy to contract administer. I think that's the main things that I think an architect has to really look into.
So just sidetrack a little bit. So I think from the earlier question until this point, right, I think there is a sort of view on the architect's role and a contract administrator's role, and more often than not, we wear both hats in projects. So I'm just going to throw a wild question out there. Do you think that that's the right setup? Or should it be separated?
Honestly, I would say it ought to be separate, honestly. I mean, having sat through that role, wearing both hats, and then essentially then after that being separated, architects, we are very romantic creatures. We want to safeguard our design because we feel that we can save society because our design is such that I mean, a great feature to have. But however, what happens, as Stephen just pointed out, you can do all the wonderful fluffy stuff, right? But if you don't write and spec it well, right, it remains a dream. It cannot be executed well, and you may end up actually having to clean up the mess that you created upstream, which is actually quite common. So in order to kind of like circumvent that kind of grief, if you have two different parties that actually administer it, and one can concentrate on the fluff and the other can concentrate on making sure that it's on time, then I think administratively it probably would run better. But however, having said that, if both parties happen to be architects, right, that's a different cat fight altogether.
Or for that matter, if the other party is non-architect, you end up,
Yeah.
And I mean, I tend to disagree. Okay, I mean, bringing another party in as a separate contract administrator, I mean, from the contract's point of view, it kind of makes sense. But in reality, I feel that you're actually bringing a potential dispute between the two parties. One more party will come in and you say that, well, architect, it's your fault, and therefore contractor has a right. You're going to claim VO, but now who's going to pay for the VO, and then you have to account to the client. So, but if kind of you are the designer and you can kind of contract minister, and somewhere down the line mitigate
More
the
room
issue.
to maneuver
That's
the changes.
Yes and no. Okay, I'll just share a recent. I mean, unfortunately, I'm also the so-called the claims assessor in my organization. And one thing that I come to one of my directors had asked me to have an independent view of one project that we were running through that kind of problem where we were both architect and contract administrator. Imagine the horror that you discover that, the specs were not quite up to it, the drawings were not quite up to it, So if you look at it very objectively speaking, right, then it's like, done, it's our fault, But the thing about it, if I take Stephen's point, I'm not disagreeing. But I take your point, I would be very inclined to say, okay, how do I get my colleague out of shit, And that's where the lines get very blurred. Then are you, back to your original question, are you being fair or not? You see? But the point about it is that, I think most of us architects, me included, right, would try to deny everything, even we know it's our fault. Because, for the basis, they say that let's not focus on the fault, let's focus on getting a solution, you see, right? Because the minute you own up, right, then what happens is that everyone's focused on doing a rugby scrum on you rather than say, let's fix it, Yeah, so that's how I personally felt. I mean, thank God. I mean, in a certain sense, we were able, as to Stephen's point, for that particular exercise, we were able to negotiate and weasel our way out with minimal damage. Yeah, other than a few slaps on the hand.
Okay.
Yeah.
So another question is, have you encountered scenarios where the client insists that an item is a defect, while you do not feel that it's a defect? Like it's within, let's say, construction tolerance.
I'm actually doing an expert case on that right now.
You are?
It's very
Great that this question popped up then.
I think it boils down to client education. I'm not going to name the material because it will actually kind of like reveal a lot of things because this is quite a rare case. But fundamentally, but this is, I can tell you that it's actually about timber. Now, if there are certain species of timber that you are supposed to be able to understand that it needs to become worse before it can become better, then you can't expect that the timber is going to weather very nicely in its early days. But to the client, you said that's a defect, you see, and they insist that that's a defect. To the point that that's the reason why I was invited to be an expert witness to provide a third-party view to say that, hey, this material has to be loud. I mean, it needs to rot before it can become better. See? So it's about client education, because what the client sees is really the end point after 2-3 years when it has settled and steady state and say, oh, it's beautiful, but they've not seen the birthing period of it.
it's also a lot about manage expectations for
Yeah,
the client.
expectations, correct.
So for example, I did quite a fair bit of precast facade works, and those are off-form precast facade works. And the finishes will not be as perfect as you expect it to be. Like every panel will look exactly the same because it's concrete. You have some tonal differences. And we have to explain to the client that this is part and parcel of that look. You know, if you want a precast look, that is something that you need to accept too. You cannot be expecting every panel looks exactly the same. So you have to educate them even before you propose the idea that this is something that you need to be aware of. And so when it's built, they more or less accepted the idea that, okay, there is someone that they are looking for. That is kind of look they are looking for. Yeah. So if you just show them nice perspectives, everything's the same color, everything the same tone, they will reference back to the as-built. How come it looks so different? So you have to have some reference photos from previous projects to educate them. Okay, this is something that you'll be expecting as a true project.
So I think I will take that advice because for us, when we do 3D rendering, some of the programs you can click and drag the weathering, make it look more tarnished and older. So at least you buy yourself some insurance.
Oh yes, and more importantly, put at the bottom, artist impression only.
Yeah, okay.
Yeah, otherwise they will hold that as you.
Okay, so I guess apart from DLP, completion of the project, the question here is, what you always ask yourself is, when it's at the right stage to certify or not to certify, whether it's satisfactory or not, what would hold you back from certifying in such a scenario? Is there anything that will hold you back from certifying?
I'm not too sure if you want to use the word hold back,
Yeah.
but I think, probably your organizations all know that, the client wants to be informed before you issue out a certificate or anything like that, you see, for any reason. And what happened was that, one of my recent, again, it's not my project, again, it's my colleague whom I'm asked to do a so-called a peer review on, where, I was asked a question about fair and objectivity, and in my view that, okay, ticked all the boxes, we've got all the condition precedent there, yeah, it's okay to actually issue the completion cert out. And then, of course, make sure you've got a schedule of defects to fix up. So that's following the rules. Then what happened was that the client was the one who said that, after that, the QP decided, okay, I'm pushing it out because, time, the clock's ticking away. Client came back and said, you should have run it by us first. Of course, our defense was very simple. We do not want to be seen to be influenced. Typical get out of jail card free. And then the client turned back and said, it's not about what you call being fair and objective. Our QS, because this particular project, the QS belongs to, is on the side of the owner, said there were certain matters that needed their sign off as part of the completion process, which, because you had issued a completion cert, these items were not met. Had you had run this through us, we would have asked you to also review through these particular elements that the QS was holding, and then you can happily issue out the completion cert, you see. So in a certain sense, it kind of like brought me thinking that, we are so brought up in the fair and objective kind of thinking, and you shouldn't be influenced by a client. But, in nowadays when you have these multi-party type projects, right? Sometimes the client needs to also have his say to go in order for the process to be able to come to conclusion. So my takeaway for that one down there is, okay, just basically tell the client that you're going to issue the completion. Do you have anything to insert, rather than say, it's the way how we craft the email. Don't ask him for permission. Tell him that you're going to do it. Ask him if he's got anything you want to add in. Then at least it's not seen to be influenced. Yeah.
Yeah, I totally agree. And I think for some of the projects, particularly inside the corporate or even stat boards or government agency, It also depends on who the SO is for the contract. Often some clients want to put them as SO and consultants or architect as SO rep. And therefore, then you have to, especially the PSSUC, then you have to understand what is your role as a SO rep and what's the role of an SO, right? And then you need to draw that line very clearly, and you do not want to, as a SO rep, you do not want to take on the responsibility of the SO, okay, and vice versa, you know. So I think that's something that practitioner has to take note of, particularly in the PSSUC.
All readers.
All readers.
Typically, we tie the completion cert to so-called the TOP cert that you obtain. So after your TOP cert, you more or less can move in to use the space, so you issue the completion cert. But depending on certain projects, we are very specific. For example, if you have a factory, if the intent is that they need to use certain machinery in order to produce their products, if that particular machinery is not in, although you have completed your TOP, the client cannot actually use the space for their own purpose or whatever. So then we will not actually issue that completion cert. It has to be completed to a certain extent that the client can fully utilize the space or reasonably use the space for their works.
Mm-hmm.
So
yeah, I like to chime in on that bit down there. I tend to disagree trying to lock it down to TOP because I feel that TOP is a statutory process and the contract is a commercial process, you see. So just hitting TOP does not necessarily mean that all the conditions in the contract have been fulfilled. So what I would normally put would be TOP is a condition precedent. I think the key thing that we want to be able to mark in a line in the sand before I issue a completion cert is, would the client be denied enjoyment of his space? So in a factory, if he can't produce his goods, he would not have been able to enjoy the use of his premises. Similar residential, you know, if you get me TOP and I can't move in because I haven't passed QM or anything like that, right? You know, that time I think I may be 6 months from moving in, you know, but I'm starting to pay property tax, right? Because I've got TOP, you see. So and again, one of the cases in my office was that, you know, because the ER, this case was a Redas contract, the ER had certified that okay, good to go, completion cert can issue, but he had forgotten that there was a statutory process that needed to also be fulfilled, and that was where some complications came in. So I think one of the things that I would normally err towards would be basically to separate TOP from the completion cert itself, from a contract perspective. Yeah.
I think because not forgetting on one hand, for the contractor side, their completion and their LD and everything is packed to this completion cert as well. Okay, so maybe one question is, maybe for all of you, what is the most serious chain reaction problem you have encountered in your project administration, contract administration experience so far? Of course, not revealing too much that it becomes a problem.
Okay, I'll quickly start off.
Okay, I can see you're excited to do that. Okay.
No, I want to get it over with.
Okay.
No, one of the projects I'm most well known for is running on the Redas form, and if those of you who have run Redas before, you realize that within the contract provisions, right, there's no delay cert, you know. So there's no delay cert down there. Then what happens is that, you know, unlike SIA, you know, they hit the date delay cert, then you have termination, then have that restart of the delay cert again. So very clearly, but the Redas does not have that provision. So what happens when the project actually hit the original contract completion date, which was still far from completion, you know, I had no instruments to issue out, to warn the contractor. So what I did was I did a letter out to warn him that he had already crossed that particular date. The irony of the whole thing was that the client then sent me a nasty letter saying that you have no right to do so because the contract gave you no such powers. Because the contract is silent about it. You have no powers as an ER to issue such a letter, you see, because there's no delay. But subsequently what happened was that because of my letter, they were able to later on during the final account assess where was the line in the sand. So in a certain sense, but the exoneration came years later, but in the meantime I had to live under the umbrella of being, somebody who didn't administer the contract to the letter of the law.
How about yourself?
I think in most cases it boils down to dollars and cents. Okay, any project is about time and cost. And often these things, when it gets into this, it's an issue of contractors complaining, I'm not getting paid by the client, and therefore an issue, or the other way is client will come back and say, hey, project's been delayed, I can't move into my premises and there's this delay, and it's usually those situations, and I think as contract administrator you have to really go by the letter. So in effect that will not only protect your own interests as a contract administrator and an architect, as I mentioned, it also helps to educate the client to say that, look, if you administer it in a proper manner, the less likelihood of the client getting a situation where they are at the losing end of a dispute.
How about?
I think for myself, it's when I run projects, I often wear the architect's hat more often than the contract administrator's hat. So as you run projects, doing coordination works, you start giving instructions, you start making changes because of site coordination. And often or not, all these costs will start to pile up. But the contractor will not highlight to you. They will park it all towards the end, towards the final account, then throw you one lump sum of cost. Say, Mr. Architect, you have changed this, you have made these changes, and I'm going to charge you this. Which in the first place, we are not fully aware of that implication of the cost, because that has not been highlighted to us. Then when you put up this cost, client will start to look at consultants, why do you make these changes? Why was this not highlighted? So that becomes a negotiation effort between QS, architects, and the client. So that is usually a long drawn affair after the contract is completed to close the final account.
Also, to chip in here, I think at least in my experience, right, you need to be able to discern between an opinion and an instruction.
Yes.
Because project managers can tell you whatever they want to tell you, and to your point, the cost is not known to them. So later on they'll say, why did you do this, and you said, well, you said it and it's minuted, and he'll turn around and say, that was just an opinion.
So I think interestingly, because also quite recently I told my team members to make sure that even though we communicate through WhatsApp, it's important to send, whether it's a document or anything for confirmation, through email again.
Yes.
Because like what you say in the group chat, not just people added later. Nowadays, we can connect our WhatsApp to the computer. You can sign in to the computer. One thing I realized is that I can open the file in the computer, and a month later, I open the chat in my chat, trying to look for that document. I cannot load it anymore. And on top of that, also to viewers at home, nowadays, WhatsApp, you can have disappearing messages.
Yes.
I was trying to trace back to one of the chats with the clients also, because he confirmed on something. I was trying to look for it, and I say, "It is full of change to disappearing messages. I didn't even know, So this becomes a problem. I know back then I've also consulted lawyers before where they say, WhatsApp is still, it can be considered as a confirmation. But with all these disappearing messages and things like that, it's still messy. Still email is still the best thing to fall back on.
In fact, in administrating the SIA condition of contract, something I learned in one of the firms I work with, where I had kind of a contract manager who was kind of mentoring us, and he made it a very good point. He said, at that time there wasn't WhatsApp, and even emails was quite new then. I'm not sure how old we are. So we say all documentation, all correspondence as far as contract is concerned, it's either AD or AI. Okay. Don't issue a letter that doesn't state anything. So that kind of keep the contract administration documentation very clear. But now with emails, with WhatsApp, it becomes challenging and how to kind of put everything together such that you have a good log of what has transpired, throughout the whole process. Yeah.
Okay, so I guess that's more on the contracts and the communication. But what happens when you meet a rebellious contractor that doesn't listen to your instruction or direction? What do you do? I think this depending on what form of contract also, right?
Depending which
boils down to
nation.
two things: cost or time. So if they don't listen to you, it's either a cost implication or a time implication. So you just have to get this clarified. Why do they not want to listen to your instruction? It's usually these two things lah.
And it usually happen because the contractors is appointed by the client directly. Some friend's friend. Right? They only listen to the client and they pass it
to kind of like give a little bit more depth to your question, right? I would want to say that if they don't want to listen, right, as an administrator, I think it will be useful to try and find out what triggered it first. Now, for example, we all know exam question. If the contractor is already in delay and you issue him a fresh instruction, right, you're essentially riding on his delay to get more things done, and he'll potentially get into further delay. So of course, a smart contractor says, I'm already in delay, I'm not going to fall into your trap and end up in further delay, and that's why he needs to do that. So if we can understand that, right, then we know the objective basis why he has declined to carry out instruction. Or perhaps maybe his payment has been held back for so long, right, that he cannot continue to bankroll it, because I think a lot of us don't quite realize the poor contractors actually put out a lot of money up front. Actually architects too, we are subsidizing our client. But it's about no oil left to oil the gears.
So usually at the end of the project.
Actually, not really. I've actually encountered exactly that one down there, but simply because the contractor actually, on one hand he wasn't very he wasn't very hardworking in that sense, but at the same time he had a very good programmer who actually basically told him his critical path and all this kind of thing already. So he knew upfront why he shouldn't take on the extra instruction, Yeah. And then, when we point out to him that, hey, the contract requires you to accept it and this kind of thing, right? He tried to contest it in that particular sense. Yeah. So understanding before we become judgmental, right? I think it's back to the temperament part.
Wow, I didn't realize the first question will relate to the rest of the questions. Okay, in the more commonly used standard contracts, there are of course contractual powers and mechanisms for you to handle such situations. So what if the client has signed a non-standard and very simplified contract prepared by the contractor? So how have you encountered such a situation where the contract is obviously when the contract is drafted by the contractor, it will lean towards their benefit, right? So
I've encountered it more as an advisory role when such situations happen now. And as you say, well, the contract is a contract. The client has signed it with the contractor, and most often than not, it will be at a disadvantage to the client. So we'll just say that, well, if it comes to a certain situation, you just have to find ways to terminate it, or you have to ride through the contract until the end because that's what they signed. In fact, this situation came about not locally, but overseas, whereby a young architect turned developer developed something overseas, and for them they kind of signed the contracts with the contractor, and the contractor midway through the thing just says that, oh, I terminate my contract, and that's it. And the architect, so-called architect developer, has got no recourse, and being young and inexperienced, he came back to me as a friend and said, what can I do? And I said, well, show me your contract. And read through everything and say, look, you have no recourse, just let him go and we've got to start all over again. I think that is the issues with currently, particularly houses. You get a lot of house owners getting offers from contractors, design and build arrangements, and often they're not familiar with the contract, and they just see the dollars and cents part of it and say, wow, I'm going to get my house at such a better rate than if I'm going to get an architect, and everybody to start. And I think that's where they kind of fall into situations like that.
That's actually the topic of another
Alright,
expert
that's another
witness.
subject.
No, but that's another topic of an expert witness that I recently concluded.
Okay.
Right? So in this particular case, there was a so-called contractor drafted, and then after that later, it was between a main con and the subcontractor. Subcontractor failed to perform, and subcontractor said that, well, it was a friendly handshake, But then I said, so as an expert, my view would be basically very simple. I see your signature on 297 pages of the so-called handshake contract that you have signed. So whether you like it or not, in the eyes of the law, you have agreed to it. So you must perform to it, you see. So, as Stephen rightly fully put it, you better know what you are signing before you put your fingerprint on it. Yeah.
I think that applies not necessarily to the client and the contractor, so architects with client as well.
Yeah.
Yes.
Yeah, there's a lot of fine prints that you need to read.
Okay, so with all on the topic of contracts, how do you feel about a scenario where the client or the contractor comes up with their own form of contract? You would then have to, so a few things I thought about was that you would then have to familiarize yourself with a new contract. Okay, then depending on how comprehensive the contract is, it may land you in dead-end scenarios where you have limited contractual power, because I think the contracts that we are familiar with, obviously, we have played out many scenarios. It's probably gone through many iterations already, and it drives you in circles, and much more time is needed to contract manage. So it leads me to the question do you think that architects should charge more for having to administer non-standard contracts?
Architects should charge more, period.
Correct. I agree. And for such situation likely, I'll not take on the project. It's too risky. It's too risky.
You don't even have a template for you to base on how to.
And even if you charge more, you do need a lot of time to understand what's in the contract and to test out different iterations to see what are the possible scenarios that could happen. Yeah, I think that will take a lot of time and effort. So even if, depending on really how much you charge, may not be worth the effort.
Actually, I wouldn't mind taking on if I had in that arrangement the powers to offer improvements to that contract. To me, very, very straightforward would be basically what are the client's obligation, what's the contractor's obligation, what are the client's remedies, and what are the contractor's remedies, and what is the arena for resolving disputes. These elements must be in the contract. And then beyond that, right, if you want to have your chicken rice, as I would put your chicken rice type contract, right, where you show a photo of a drumstick, but you deliver a chicken breast meat plate, right, that's separate. But partially because I'm so involved in the legal process of so many kind of things like that, I've come to realize why, rights, obligations, and remedies, these are my key go-tos for any contract form.
Yeah. Which I mentioned, you require additional time.
Yes, correct.
I think that's...
And that's why you must charge more.
Agreeable, but how much more to make it worth a while? If you are really... Again, I think it depends on individual practices.
Yes.
All right. So if your practice involve you as an architect, not just as a contract administrator, focus, then you may not have the resources to spare the additional time and effort to look into those aspects of it. That is for my practice.
But actually, I'd like to ask that question back, you see. When we pitch our fees, for example, are we pitching it to so-called the blue book with that little graph down there? Or do we actually look into the resource and manpower requirements to service the account? When in my days as a self-practicing sole proprietor, I used to follow the blue book, so to speak, and I realized that it was actually not equitable to the effort put in. Right now where I am, we are totally the opposite, you know. The minute, even if you want me to do a small little guardhouse or what, right, I will pitch in, you know, who needs to be there, how many hours and all this kind of thing, even as an estimate, right, and arrive at a fee proposal. So I think really, you know, back to the earlier mention about how do we charge and how much is it, right? It's about matter of manpower, as you said, versus resourcing and whether or not it is worth the financial reward. That's basically it.
Yeah.
So yeah, I mean, one very veteran architect used to tell me when I was much younger, was saying that, you know, you can't keep running away from unsavory work, you know, because if you do that, right, you have nothing to practice with, you know.
How about you? Have you encountered scenarios where you might have to?
Not really. So far, we have been practicing based on either SIA or PSS COC. So, provided we can influence the contract, if you have already signed a contract with a contractor, for example, the client already signed a contract with a contractor and ask the architect to go and administer the contract, I don't think it's wise and also not fair to the architect who was going to administer the contract also. So unless, like what Harold has said, you are able to influence it and include the terms that is help us to administer the contract. If not, I don't think it's wise for us to administer a contract that is not drafted by us. Yeah.
Or rather, it takes your teeth away. Is it?
Yeah.
Because for me, I work on the landed houses.
Yes.
So obviously the clients engage me already, and then I have my service agreement with the client, and very often when we call for tender, they might have, you know, uncle's friend's friend or whatsoever, and they pull all sorts of contractors in, and there's a lot of influence, different type of influence going into their head, you know. So I quite often encounter scenarios where they say, of course I would advise, you know, maybe go for SIA contract, you know, but they say, no, they tell me that this contract is very good and everything. So I always have to look at different kind of contracts, and of course, in my opinion, I'd rather just run the standard one because it protects the client also. But quite often they don't align, they may not align with that, and they end up signing a simple contract.
But do you adapt some of the SIA portion to that self-constructed contract?
I do spend a bit of time to advise on certain clauses that should be put in, but of course, like what you mentioned earlier, we have to put in additional time. But I don't have an opportunity to, or rather, I haven't tried claiming for additional fees in that aspect, but maybe I should start. but yeah, so there are situations like that. But you run in a situation where you are engaged, your service agreement, you know, you're supposed to manage the project and administer the contract, but the contract is garbage, so you don't have a lot to work on. And there was one where the contract was so simple, and when the works were not satisfactory or they were behind schedule, I just had no contractual power except but to write a letter or email of plea to the contractor to say, please hurry up, the clients have been, you know, renting a place for too long. So those are the situations. I think it's more evident in landed houses, contracts for landed houses. Yeah.
I think you brought up something which I think we were just discussing earlier, in the sense that what is in our appointment agreement. I think through the years as we practice, we tend to tweak our appointment to kind of cover those loopholes. And I think this is one possible area to say that, well, you know, your role in your agreement is to administer this form of contract. You know, anything more is either chargeable or you know, not acceptable. I think, well, through 30 years of setting up my practice, you know, along the way we keep changing our letter of appointment to plug in all, you know, we got caught by the client in finding a loophole in there, and you keep plugging in all this.
It
loopholes
just
along
gets
the way.
more and more. Thank you for that. Tonight I will put that in. Okay, so another question is, should we even be involved when there is a dispute between the contractor and client?
I think you have no choice.
Yeah, correct.
Yeah.
I think you have no choice. But to what extent of your involvement, I think that's the question. All right. I think when it goes beyond a certain thing, you may tell them, you better go get a lawyer, you better seek legal advice or go to arbitration or
Yeah,
etc.
correct.
Yeah.
Your role as a contracts administrator, should you be wearing architect's hat while acting in the capacity of a contracts administrator? Actually, I think that was the question earlier already.
Right.
Yeah.
Okay, that came naturally.
No, but that's exactly where we differ in opinion.
I guess viewers can chime in on that, in the comment section, and we'll
Yeah.
see how what other people think.
So
right?
I vote that the answer is no, we should not be an architect while we're contract administrator. Steven says no, we should be both. Right? What's your? So see how many likes we get.
Okay. Let's see the comment section. Okay. Should you be commenting on design matters while acting as the contracts administrator? Of course, in this scenario, you're acting as both lah. Should you even be commenting on design matters while acting as the contracts administrator?
Well, I mean, you are playing both roles, so you should. In fact, it's just that you have to comment it within the domain of the contract, and not going beyond, or you can go beyond what is in the contract, and then you just have to, understand the consequences of it, whether be it resulting in a variation or resulting in extension of time. I think it's inevitable. I mean, you are the architect, and if you see something wrong, and I think it's more important, if you see something wrong, you better amend it on site before it becomes another issue.
Well, it depends, and I was going to add to that. Okay, I'm on your side this round. But if I had to do both, right, I need to draw the line. Is my intervention as an architect to make it comply with, say, a CA requirement, or am I trying to sneak in design improvements? I think we need to separate these two out. I mean, to sneak in a design improvement at construction stage, to me, is not quite right. Because the client already signed off on something that was not as nice, and then there you go, trying to improve it, thinking that you're helping the client, but in actual fact, you're going to open a hornet's nest for yourself. But, to actually make the changes in what we call compliance to a written direction, you already have a supporting reason for doing it already, and you are empowered to do so. So no dispute. Yeah. So I mean, I in my current work, we get a lot of trying to sneak in design pass sign off. You see, so that's exactly where, again, temperament again. I could go to the designer's office and beat him up, but
I think we need not to be a sneaking kind of situation. It can be something that you very openly tell the client that, hey, we think that based on our thinking right now, compared to what you have designed maybe 1 year ago, we think that this could be a better option. So we bring it up to you, whether they are acceptable to the design changes, and being very open about how we think it can improve the project. Then we just tell the client, if they are okay, then that's all good, and we can issue the instruction to the contractor.
Yeah, I suppose if the contractor also back you up with calculated whether there's any VO or not, so that the client can make an informed decision, knowing it's an improvement, whether there's time or cost implication, then they can say, okay, better, why not?
I mean, it boils down to design is an ongoing process, right? I mean, every project we finish, it's never the perfect. As an architect, as a designer, you're always looking for the perfect solution at the end of the day, the perfect project. And I think that's what makes the practice interesting, as each project is something new, and keep going.
So even currently my project, I'm also doing design revision, although we already started the contract already, and some of it are actually cost omission or cost reduction, so that we can help the client to save some cost here and there, and that is on my own accord, and not even instructed by client, and that is on top of all the design work I've already done. So I actually put in more effort to help to revise the design to make it more cost efficient. So this is really to bring better good to the project also. So you have to bring it to the client that this is not just about the architect's desire or ego to make it a beautiful project, but also to make a project better as well as more cost efficient.
So that's actually what you mentioned reminds me of another question that we had talked about in the previous session, which was if the client asks you to, because we have what we call value engineering. So what if the client asks us to do value design, to revise it and bring the construction costs down much more significantly, which entails a lot of work, a lot of time, a lot of effort. Would you normally then tell the client that this is chargeable?
Again, I think really depends on the situation, how much effort needs to be done. I mean, to give a real life example, we were asked to design a building, right, on a certain size of area, and the client's instruction was, well, we need to get this out quickly as usual, tight timeline and everything, so we rush. And halfway through the tender, the client says, stopped. Okay, we are considering looking at another site. So okay, we stopped, and we helped them look at the other site, and they found that, okay, that site, and they changed our mind, and then they say the site is not suitable, we'll come back to this site, but now our size double, the site double. And they say, well, you shouldn't be charging because we're coming back to the same site, you already done the drawings, your drawing can be reused. So our argument is, look, the engineer has already done their work, the span has all changed, so we practically start everything on the new, right? And all the compliance with CA has changed as well. Now your site is bigger, your fire safety controls and everything may change. So in the end, we argue it and we got paid for so-called omitted work and start everything project as a new, right? So again, really it depends. And then one of the situations I encountered many years ago, particularly with working with houses, client will set a budget, okay, whether it's 1 million, whatever it may be. And then you're working within the budget. And then when it comes at the end of the day, the projects, the client will say that, well, why are you proposing ceramic tiles? Why can't we have marble? And you go back to them and you say, well, you have a budget. You told me this budget and we met your budget. This is the project you get. And the client says, how much more is going to cost me? 10,000, you should tell me, then I'll pay the $10,000. But where does that $10,000 going to end? Every item is going to cost you a few $1,000s.
Yeah.
So now our approach is the other way. We propose what is best for the client. And then we tell them, look, now the construction cost is going to cost you twice of what your budget is. So what do you want to do? We can do value engineering by reducing the material. Okay, you can't afford marble, we go for ceramic tiles. You can't afford timber windows, you have to go for aluminum windows, etc. So at the end of the day, they can't argue. I say, well, you give it the best of what we think is the most suitable for you, but you have a budget, then you have to decide what is a priority. So we kind of change the approach through the years. Otherwise, we get client coming back and say, hey, it's another $10,000, you should tell me. Then I can afford that 10,000. Say, but you told me you have a budget.
I think this approach where you give the maximum option and then they pull it back reminds me of one item that I put in my own contract, because for example we have projects where homeowners, some of them they may be retired, some of them have more free time. They drive by their new house every other day and they say, I engage you guys to look after my project. Why are you not there? Every time I'm there, I don't see you guys there. And I explained to him in our contract, once a month or maybe twice a month at most, we do periodic checks. We are not there all the time. So I've encountered this a few times, and to the point where I thought, okay, what's the best solution? So now when I put out my contract, I will put an optional full-time site manager from the architects team at how much per month. Obviously they're not going to take it lah. But because I put that there, after that when they do question me, I say, oh look, we put an option there but you didn't want it. But so actually that's why I always is twice a month, once a month, periodic checks.
So you're plugging in the loopholes.
Yeah. So I think we always set sail with a boat with all the holes. We just need to see what to shove into the holes. Okay. Thank you so much for coming down today. We have come to the end of today's session. If you have any questions, comments, drop them in the comment section below, and do continue to support us in the rest of the videos. All right. Thank you very much.
Thank you.
Thanks.
Thank you.
If you have liked the session today and find it useful and helpful, We would really appreciate if you would like and subscribe to our channel so that it will encourage us to continue doing what we do and bring more exciting topics to you.